This podcast is brought to you by Osprey Approach. In conveyancing, fixed fees mean every minute counts. Too much admin eats into your profits, and inefficiencies slow transactions down. Osprey Approach is a legal software built for law firms, helping conveyancers stay in control by managing cases, accounts, documents, and compliance all in one place. From automated client updates to post-completion workflows, Osprey streamlines every step, cutting admin time and keeping transactions moving. Osprey Approach. We make running a law firm easier.
You're listening to the Today's Conveyancer podcast, the leading source of information for residential property lawyers in England and Wales. Don't forget to subscribe and sign up to our free newsletter at todaysconveyancer.co.uk. You can also follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Conveyancer podcast. We are back with Ian Quayle doing our short series on topics around the conveyancing process and trying to impart some information and expertise to practitioners. Today, we are talking about moths. No, not an acronym, actual moths. Many of you will have read about the case where a vendor has had to purchase back essentially his £32.5 million home.
Yes.
Because of an infestation of moths. Ian, you're going to talk us through this case.
I am, David. And first of all, I don't know if you can see what I've got in my hands, but if
You've got a moth in your hand.
If I open it very carefully, there he is. I have a moth. Really interesting case. Hi, everyone. Thanks, David. Let's be sensible about this. There's been quite a bit of case law over recent years concerning the TA forms. I don't want to talk about the TA6 and the TA7, David, because we've talked about that in the past, and we can talk about it again in the future. But for 10 minutes or so, I just want to remind practitioners about the significance of TA forms from a seller's perspective. And then we'll have a look at this case and see what we can extract from it. When acting for a seller, I think it is so important that we tell the client the importance and significance of answering questions in the TA forms honestly and frankly. David, it always seems to me that it's quite a difficult task to say that to a seller, because if I'm selling my house and you're buying my house, the last thing in the world I want to be doing is telling you about the problems that I've got that you could get as a consequence of acquisition. So there must be a sort of inherent desire on my part to keep things that are problematical under my hat. The whole idea of the TA form is that can't be the case. You have to be full and frank, disclosing on behalf of the seller everything that you know about the property for the benefit of the buyer. Now, in the past, there was loads of case law, William Sindel PLC against Cambridge County Council, all sorts of other stuff, where there was some quite interesting legal issues. Recently, there was a case called Rosser against Pacifico, where a judge quite rightly said, look, with regard to TA forms, you've got to understand the premise sitting behind them. The seller is in a far better position to know about the property they're selling than anyone else. So in essence, what the judge is saying, yes, we have this principle of caveat emptor, but with regard to the TA forms, the seller is sort of parking, let the buyer beware, and helping the buyer with regard to the decision-making process. And again, what the judge was alluding to there, I think, is some of the wording on the front of the TA forms, which, David, as you'll recall, they're saying to the seller, you've got to answer these questions honestly. You're not expected to get legal advice on the answers to the questions. Just tell the buyer how it is, because the buyer is going to rely on this information. So in Rosser and Pacifico, same thing. The judge said, look, the form is designed to help the buyer. The forms warn the seller about the dangers of taking a rose-coloured spectacles type of approach to answers, or lying with regard to answers. The forms couldn't be clearer. You've got to be straight, okay? Now, in Rosser and Pacifico, the seller's solicitors at court and the seller's barrister said, if you're buying a property, you're instructing solicitors, they're performing due diligence, you're having a survey. So really, the TA forms aren't that important. Whatever the seller says doesn't really matter. You've got people protecting your back, undertaking due diligence with regard to the property. They should be the ones that are checking, investigating, etc. And really, the TA forms are just a sort of procedural sort of guide or some sort of minor assistance. Judge said no, absolutely no to that. Very important forms have to be completed seriously. So, in this case, which is described as Patarkatsishvili against Woodward-Fisher, okay, in this case, £32.5 million property, Horbury Villa, Ladbroke Road, London. Unfortunately, David, people aren't like us and can afford expensive, nice properties. They've got to go cheap and cheerful, and that's what this poor buyer did. On moving into the property, he and his partner quickly discover they've got some friends with them, namely clothes moths. So not your ordinary moth like I had in my hand a little earlier, David, but these little blighters will eat anything and everything, right? And unfortunately, the claimants in this property, given the fact they were paying £32.5 million for the property, had some very nice items of clothing and very nice carpets and curtains and all that goes with it. And our friendly little moths must have thought all their Christmases had come together. Now, the position was that the seller, in renovating this property over the years, was keen to promote his eco credentials, and instead of getting bog standard insulation, got wool insulation. And it transpires that the wool at some point had been exposed to cloth or clothes moths, and clothes moths like warmth and they like damp and they seem to like sheep's wool. So these were sort of encased within the walls of this building, and surprise, surprise, warmth and damp, out they come through any sort of apertures that there were with regard to the property, and there was a problem. Mr. Woodward-Fisher was aware of the problem. He'd instructed pest control companies to come out and have a look. Now, I'm not sure what happened with regard to the pest control companies, but they clearly failed in their task. So Mr. Woodward-Fisher, who's a bit of a property developer, says, right, I'm going to sell. In selling the property, he is provided by his solicitors with TA forms. And those TA forms included standard questions. Did you know about any vermin infestation in the property? Have you received any reports on vermin infestation on the fabric of the property? Were you aware of any hidden defects in the property? Now, it seems to me that when I look at the report, it's not clear what Mr. Woodward-Fisher did. Did he just complete the forms without seeking advice from his solicitors, or did he ask his solicitors how I should answer the questions? I think the latter is the case, and I think he was told that moths aren't vermin, and I think he was also told or surmised that infestation wouldn't mean a collection of moths sort of hiding in the lamb's wool or in the sheep's wool that was used for insulation. So for whatever reason, he doesn't answer the questions honestly at all. He sells the property and our buyers move in and quickly discover the nightmare. Moths flying around all over the place, carpets being eaten, clothing being eaten, etc. And they decide that they're going to sue the seller for misrepresentation. First point, David, they've got a few quid, so unlike you and I that might balk at the thought of spending £50,000 or £60,000 to bring county court proceedings, these people are quite happy. It's small change, so we go skipping off to court. Mr. Woodward-Fisher defends the proceedings and basically relies on Rosser and Pacifico. Let the buyer beware, undertake your own investigations, carry out due diligence, etc. In the course of the claim, and in the course of trying to find out how to get rid of these moths, the claimants instructed pest controllers, two of whom said, we'll come out and we don't really need to know much about the property because we've been before. Mr. Woodward-Fisher sent us along, which really threw him well and truly under the bus, didn't it? So off we go to the High Court. Surprise, surprise, our defendant loses spectacularly. Okay, he said, what I said weren't misrepresentation. He denied that he knew they were false, okay? He denied that the buyers would be relying on what he said. Judge wouldn't have any of it. The judge said, first of all, let's look at a dictionary and let's look at what vermin could be described as. And he said, insects could be vermin. And he said, even if I put aside what a dictionary says, in the context of this situation and the amount of these moths fluttering around, they were vermin. That's point number one. The second thing that he said was this was a residential property and anything harmful could amount to an infestation. and the moths were harmful. The judge looked at the inquiries and said, well, the whole purpose behind these inquiries is to let the buyer know if there's any hint of an infestation. It was obvious that these moths could damage the property and adversely affect the enjoyment of it, and their existence would require expense in order to eradicate it. He said there was an infestation of moths. It was an infestation of vermin. Therefore, these were misrepresentations. Interestingly, David, the judge said these were fraudulent misrepresentations. Mr. Woodward-Fisher knew or ought to have known or was reckless in finding out whether or not there was such an infestation. In other words, the judge is saying, we don't believe what you're saying, Mr. Woodward-Fisher. Interesting thing again about this is the claimants say the misrepresentations are so drastic, so significant, we want our money back. So we want to rescind the contract. Normally, David, what you do is you claim damages for the misrepresentation. The difference between what you thought you were getting and what you actually got because the seller misrepresented the position. But here, the claimants go for all or nothing and say, no, we want our money back. And that's what the judge said. Mr. Woodward-Fisher said, I can't give you the money back because I haven't got it. And the judge said, well, I'm not interested in that. You pay them the money. They have a lien or a charge over the property pending getting their money back, and you're also liable to them for damages, for the damage that the moths have done to clothing and furniture. So it's a really interesting case. The fraudulent misrepresentation point is the point I want to talk about, David, before we finish. Remember, fraudulent misrepresentation is a deliberate lie, which I think is in essence what happened in this case. Or it could occur if you are reckless as to what you say. And when we talk about reckless, do you investigate, do you challenge or ask questions as a seller before you answer the questions? And I think that's the interesting thing. In this case, if we allow Mr. Woodward-Fisher the benefit of the doubt and say, well, yeah, it wasn't fraudulent, he was reckless in not checking out the position. And the last point to mention, David, which again is something that really interests me, if his solicitors misled him or gave poor advice as to how he answered these questions, they're on the hook for negligence. So I could see this guy potentially having a long, hard look at what he was advised to do in filling in the forms. And if there's a slightest hint that the lawyers guided him as to what he should say, and that guidance was wrong, I think they're on the hook. Which leads me to the last point. Whenever you're talking to a seller about providing replies to inquiries before contract, look, Mr. Client, these are your questions and your answers. I'm giving you some guidance and not advice as to what the questions are meaning. You answer the question yourself, answer it truthfully and honestly. And again, from the lawyer's perspective, we're not going to be liable if anything you say in connection with these questions is wrong or defective.
That's a really interesting synopsis and a fascinating case. But Ian, there's this massive drive towards upfront information, material information. There is lots and lots of talk, particularly on social media, of solicitors now being on the hook effectively for this information. Where does this decision sit in that whole debate?
Right. Well, first of all, it sits, the point I've just made about being careful in your retainer in telling the client what you could be on the hook for. You've got to be careful to say, if you're providing information or your estate agent is providing information to the buyer or a prospective buyer before I'm instructed, I'm not on the hook for that. That's nothing to do with me. Number two, and this is a matter really for the conveyancer, either you're going to say to the client, I have checked the information that's been produced to a prospective buyer or this actual buyer, and I'm comfortable with what you've said, or I've checked it and I'm not comfortable with what you've said, and these are the reasons why. So I think you can either limit liability or exclude liability, saying nothing to do with me, anything you do before I'm instructed, or take it within the retainer to say, I'll give you advice about what you've said and what your potential vulnerability for misrepresentation could be, and to tell you how you can remedy what you've said by correcting the position. I think that's the way it is. I think if you're going to do that, though, David, you've got to be charging the client more than you'd normally charge. Because, again, Rosser and Pacifico, probably the better case. In that case, the estate agent provided information to the buyer And the court said that was a misrepresentation from the seller. From the lawyer's perspective, I'm worried about upfront information being provided before we're instructed and before we've checked it. Point number one. Point number two, I'm worried about someone saying, given that material information is now being produced before you're instructed, you as a conveyancer acting for the seller should check it and remedy the position if it's incorrect. So I'm worried a bit about that.
This is a debate that could go on and on. It'd be interesting to see what case law comes out. And so far, the case law has really been in the favour of the lawyer, hasn't it? It still seems to be the case that caveat emptor applies. And we've always said that upfront information, material information, will live and die by the case law that will develop.
Most people, when acting for a buyer and performing due diligence, are likely to say, well, yeah, we've got all this information provided up front, etc., etc. I'm going to do my own searches. I'm going to make my own inquiries. I'm going to check and cross-check it. And the reason you do that is that if I'm relying on information provided by someone else, particularly searchers, if that search is wrong, all I can do is advise my client we can sue the search provider in negligence. Whereas if I've instructed or obtained the searches myself, I have a contractual relationship with the search provider, which means I can sue for breach of contract. I mean, that circle needs squaring, or that square needs circling, one way or the other, and it hasn't been as yet. There is another issue, David, with regard to all of that, and that is the sort of trading standards consumer protection position with regard to what an estate agent or what the seller or the seller's solicitor is producing. And that, again, is another story for another day, and a really interesting and quite technical debate needs to be had about that too. A solicitor that's giving you advice and guidance about providing material information that's defective or concealing information that should be provided, I could see the seller being on the hook for that, the estate agent being on the hook for that, and the solicitor, if acting, or conveyancing, if acting for the seller, also being on the hook, as well as the seller. Any information that you produce for a buyer or potential buyer has to be correct. If it's defective, then there's all manner of different levels of vulnerability, misrepresentation being what we've looked at today. Second thing is, if we're aware of information being disclosed to the buyer that's incorrect, the seller and those advising the seller have to hold a hand up and say, that's incorrect, this is what the correct position is. And I think if you do that, and if you act honestly and in good faith, then no matter what the potential claim, I think you've got an opportunity to escape liability. But the moment you're concealing something, or you're making a statement that isn't true, particularly if you know it isn't true, then boy, are you potentially bound to rights. The issue with the consumer legislation and regulation is, if you breach that, it isn't the buyer that will sue you, it's trading standards or whoever that will pursue an action against you. And the point there is, what sort of funding does trading standards have to pursue that type of claim, and what sort of resource have they got to investigate it? And that, David, is something I haven't a clue about, to be honest. My guess is, like every other organisation, they won't have pots of money to go chasing estate agents and solicitors, or indeed sellers, with regard to failing to provide information and material information as required by regulation.
The only caveat to that, Ian, is that the FCA are about to take ownership of consumer protection regs, and they do have teeth. This case in particular is fascinating, and thank you for the insight that you've shared into it, Ian. It leads into a wider debate and discussion, which, as you say, is still playing out in conveyancing and in the courts as well. But appreciate your insight and time on our latest transaction tips.
Enjoyed it, as ever. Thanks, David. Speak soon.
The Today's Conveyancer podcast is available on your preferred podcast provider. It's also available on todaysconveyancer.co.uk. My thanks to Ian. Thank you, as ever, for listening, and we'll see you again soon.
You're listening to the Today's Conveyancer podcast, the leading source of information for residential property lawyers in England and Wales. Don't forget to subscribe and sign up to our free newsletter at todaysconveyancer.co.uk. You can also follow us on LinkedIn and Twitter.